the court was virtually split by 6-6. 6 judges took a view that the powers of the Parliament to amend the Constitution are unbridled and the Parliament by majority can amend the Constitution in any manner. However, the 6 judges took a view that the Parliament's power to amend the Constitution are restricted and it cannot amend the Constitution to take away the fundamental rights guaranteed to the citizen. It is only the view of Justice H.R. Khanna, partly accepted by 6 on one hand and partly accepted by 6 on the other hand, which is now the view in Kesavananda Bharati. Justice Khanna held that though the Parliament can amend the power even to take away the fundamental rights, it cannot amend the Constitution in a manner in which it takes away the basic structures of the Constitution. And therefore, the concept of basic future as found in Sajjan Singh, which was amplified as basic structure in Kesavananda Bharati, is what is the law which holds the field. Various principles like the federal structure of the Constitution, the separation of 3 wings, the executive, the judiciary, and the executive, judiciary, and the legislature, the independence of judiciary, the supremacy of the Constitution were held to be the basic structures which were subsequently evolved in various judgments, including the one in S.R. Bombay. As has been observed by the Honorable Chief Minister, it is all the 3 wings of the Constitution, that is the legislature, the executive, the judiciary, which are enjoined upon to carry forward the mandate of the Constitution to bring in social and economic justice. One of the greatest weapons for promoting the social and economic justice as envisioned by Dr. Ambedkar was Part 4, that is the directive principles. And though we see that from 1950 to 1973, the tilt of the courts was always that wherever a conflict arose between the directive principles and the fundamental rights, the supremacy of the fundamental rights was always recognized. It was felt that wherever there is a conflict between the directive principles and the fundamental rights, the directive principles will have to give its way to the fundamental rights. It is for the first time in Kesavananda Bharati that this conflict was resolved. Though the court was virtually split on the question of Parliament's power to amend the Constitution, it was unanimous to hold that the directive principles and fundamental rights together and together alone are the soul of the Constitution. And therefore, Kesavananda Bharati held that the fundamental rights as well as the directive principles are together are necessary for progress of the nation. It was held that directive and fundamental rights are those rights which are necessary for a human being, for a citizen to live a dignified life as a human being. Whereas the directive principles were the principles which govern the state, the legislature, and they guide them in order to enact the laws and take steps to further the promise of economic and social justice. Some of the honorable judges also held that the courts are also states within the meaning of Article 12, and therefore it is the duty of the courts also to interpret the laws and decide the cases in accordance with the directive principles. And therefore we find that in the 75 years of the Constitution, we have found the executive, the legislature, and the judiciary to be on the same page, and particularly after 1973. Many of the laws have been enacted in furtherance of the promise of the social and economic justice, like the Agriculture Ceiling Act, wherein a person cannot hold an agricultural land beyond a particular holding. The tenancy laws, wherein those persons were tenants of the agricultural lands became owners thereof. And these all laws were held to be constitutional by the court, taking recourse to fundamental rights, particularly Article 39, 2B and C, which ensures the equitable distribution of the resources of the country. Though the fundamental rights of the citizens were affected by such enactments, the Parliament, the legislatures enacted them and the courts upheld them. Insofar as scheduled caste and scheduled tribe is concerned, to which again the Honorable Chief Justice referred with regard to reservation, the earlier view, as could be found in the cases of Devdas and Balaji, was that sub-article 4 of Article 16 was an exception to the main article of 16, and it was only a permissible way of providing reservation. But however, the 7 judges bench in N.M. Thomas overruled that view, and it held that Article 16.4 was only an empathetic way of saying that it is already inbuilt in Article 14 and Article 16. It held that Article 14 and 16 promise an equality of opportunity to all the citizens in the country. But it said that equality of opportunity does not mean that equal opportunity to all the citizens. It said that if equal opportunity to provide it to all the citizens, then it will lead to nothing else but more inequalities. And therefore, a special treatment to those who are lagging behind was already inbuilt in Article 14 and Article 16. It has been further carried forward in Indra Swani, the 9 judges bench, which held that the reservation was not an anti-meritarian, and it also held that the reservation could be provided even by an executive instruction, and it was not necessary that it has to be by a legislative piece. Recently, in the last year, we sat in a 7 judges combination to consider the issue with regard to subclassification. All 7 of us, out of 7, the 6 of us took a view that a subclassification was permissible. If the state government finds that even among the scheduled caste, a certain sections of the society, section of the scheduled caste are not adequately represented, and if it is found that only a particular sections in the scheduled caste have taken the benefits of the reservation, then the state cannot be precluded of its right of providing a special treatment to those who are unrepresented. I also went further and took a view that the concept of criminalia as has been found in the judgment of Indra Sawhney insofar as the other backward classes are concerned should also be made applicable to scheduled caste, though my judgment has been widely criticized on that issue. But I still hold that judges are not supposed to normally justify their judgments, and I still about a week to go. But if a person who is an IAS officer, he becomes a chief secretary,